which, let's add the various panelists. Okay, here we have. So the first person is the junior researcher Marialuciana Di Santi, who is currently completing a master's degree in law, specializing in tax and company law at Ghent University. And in general, she's interested in every aspect of disruptive technologies having an impact on law. And reacting to her research will be Mahsa Shabani, who is an assistant professor in privacy law at the University of Ghent. Her research focus is on personal data protection, health privacy, and data sharing. She has focused particularly on the topic of identifiability of health data in her research in view of the implementation of the GDPR. And today, Marialuciana will be presenting a paper about the proper management of health data in the fight against the pandemic, a global overview of pseudonymization in contact tracing apps. And I think especially Michael has quite a lot of experience now also with contact tracing apps. So no doubt he will also have quite a lot of input there. So Marialuciana, if you want to start your presentation.
Yes, thank you, Catherine. I don't need to share the screen because I don't have a PowerPoint. As you can imagine by the title of my paper, that is Proper Management of Health Data in the Fight Against the Pandemic. My paper is about a theme more current than ever, and it is in constant evolution and needs to be updated like daily, especially in the light of the recent events and the increase and growth of new daily cases of COVID-19. As is already known by all, towards the end of 2019, a novel virus, the so-called COVID-19, first hit China and then spread widely in Europe and America, reaching the size of a global pandemic, as it was declared by the World Health Organization on the 11th March 2020. The first containment response to this disease that spreads through the human-to-human transmission was the lockdown, generalized measures like stay-at-home orders, suspension of travels, closure of all non-essential manufacturing activities, and so on. But in most states, governments around the world have taken consideration even of smartphone traceability apps as a tool to safely ease lockdown restrictions. And in a first place, these measures was considered fine also in the de-escalation scenarios that first in a first stage could be during this time, but now with the second wave, we have to consider differently the using of smart traceability apps. Before any other consideration, it should be noted that the term contact tracing should be used to describe the overall public health strategy and actions involved in tracing and following up contacts, while when referring to the mobile apps is correct to describe them as mobile apps to support contact tracing, since by tracing and alerting users who have been in close contact, proximity with others indicate precisely a proximity tracking and an exposure notifications. We already know that these smartphone traceability apps could have a real impact, even if a large amount of the population use it, but if rolled out on a large scale, they can reach over the 50% of the population, according to some research conducted in May 2020, and so it could be of support to the public health organization of all the states. In addition, the apps can provide contacts of COVID-19 cases, even with the basic information of first aid, and so to be of help even if not get so much crowd on the system itself. The approach in the world and the use of these different instruments, it was very, very different according to Europe in general and Asia and US. My paper pointed out the fact that the approach was different, not only according to regulation that of course are different between states from states, but also for a social and cultural considerations, as we will see. In fact, the Chinese response was the first that I take in consideration on my paper, because China, as the first nation to face the pandemic, has been a pioneer in the area of digital contact tracing and implemented some of the far-reaching contact tracing initiatives, despite being subject to many criticism for the extensive use of the data of population and the still in progress development of data protection laws in China. The Chinese government is perceived by the population as a privacy protector, as a health protection and a safe keeper of all the situation. In China in particular, embedded in the popular messaging app WeChat and the payment service Alipay, China's most used contact tracing app, assessing each user a unique QR code, assigning to each people a color according to the probability of contagious. So we have red, green, and yellow. And this color determines various consequences. The red QR code obliges you to stay at home. The yellow one guarantees limited mobility, and the green one allows freedom of movement. The problem of these apps is that Chinese apps don't disclose their methods to determine what constitutes a close contact and how the app handles the data users. So the identity and the basic information of the infected user are not protected, at least are not protected with a standard that we as Europeans consider acceptable. In Europe, the situation is very, very different. In fact, even if on an initial stage there wasn't a coordinated response, and this problematic was left to the national security of each state that decides case by case how to use and how to implement smart tracing apps. In Europe, the problem of the anonymization and pseudonymization of the users of the data is very perceived by the population. And first thing that we have to note is that we are not talking about personal data, simple personal data, but we have to talk about health data that, according to the Article 4, number 15 of the GDPR, are data that reveal information about individual health status. So they are special category that needs extra protections. In particular, the GDPR at the recital number 51 reiterates that this kind of information are particularly sensitive in terms of fundamental rights and freedoms. But at the Article 9 of the GDPR, we have some exceptions that consent to process this typology of data. So we have two cases that applies to this situation, that are the letter H, that refers to diagnosis, assistance, or health or social therapy or management of health services or systems, and letter I, that makes mention of the public interest in the public health sector. So we have two fundamental rights that have to be balanced, and these fundamental rights are both important and worthy. So the problem is in finding a balance. Regarding the anonymization and the pseudonymization of the data, most of the smart phone traceability apps ensure the anonymization, but actually when we talk about anonymization is a very high standard to reach, and actually in most of the cases we can talk only of pseudonymization. So when we talk about pseudonymization, we are within the framework of the GDPR, because we have personal data, because the processing of the personal data is not attributed to a specific subject, and the personal information are kept separately, while when we talk about anonymization, we are out of the framework of the GDPR, because there is no personal data anymore, because it's completely encrypted. So I think that the problem is that the population is not aware of this difference, and so is many of the criticisms about the smartphone traceability apps are because maybe people don't understand deeply the difference between the two. And just to conclude, a brief mention about US. I said before that there is even a cultural problem. In fact, in US, there are very few cases of smart traceability apps taken in consideration by states, only two from created by the state of Utah and Dakota, respectively the Better Together and Care 19 apps. But many independent actors developed contact tracing apps. This is because in US population there is a very high sense of their privacy and their personal freedom, and so people are more, and the states in general is more pay more attention to introduce this kind of information, while in China, even for the government and how the population is react to the government is more open to a complete control of the privacy and the freedom of itself. So in conclusion, we can note that the approach are very different on the hemisphere of the planet, and this is due to cultural differences, and this is reflected, of course, on the regulation that is applied to the sensitive data, and in particular to the health data. And as regarding to Europe, it can be affirmed that the scope of the GDPR is not likely to be intended as an hindrance, but an opportunity. And even when the user gives his consent to the use of the health data, it should be the need of a regulation that can be and can keep separately the data regarding diagnosis and personal health status. Thank you very much.
Thank you, Marialuciana. Mahsa, if you would like to build upon what Marialuciana started to point towards, and yeah, just react to her research.
Sure. Thank you very much, and thanks for just giving me this opportunity to be discussant to this paper. And thanks a lot, Marialucia, for this very nice paper. And I think that it's not really even. It speaks for itself that how it is important, this topic, and it's still very relevant. And I think that just starting with like reading your paper, I think I liked it very much that you started with emphasizing the why this is necessary actually to develop such apps, and yeah, highlighted very well that the relevant issues that can be at least to some extent addressed by using such apps in different countries. And of course, maybe something that it goes also hands in hand with the topic of necessity is the the effectiveness of this solution. Let's say it's somehow pretty much it's related on the uptake and how far this is actually, I mean, we are successful in convincing different populations in different countries to actually download this app and use it. And of course, I know that, well, of course, when I think we were busy with writing this paper, maybe in spring, it was still just pretty much discussion about, okay, how we should really develop an app that it's really very sensitive to privacy related issues. But now I think in many countries, including in Belgium, where I'm sitting here now, it's also still a problem with uptake of the app and how people are, I mean, unfortunately, how this is really, I mean, the numbers are still very low. And of course, you continued in your paper with referring to what would be the lawful basis or legal ground for collecting and processing data, in this context, health-related data, which, as you rightly emphasized, and now we are speaking in this context about health data, which is very, let's say, broadly defined in the context of the GDPR, and somehow a higher protection for processing this type of data is foreseen in the context of the GDPR. And this is, of course, it's mainly because, yeah, we are speaking about very sensitive type of data, which can have, I mean, if it's being misused, it can have very serious, let's say, implications for the data subjects. You referred rightly to Article 9.2 as, I mean, the basis for processing data. Of course, I will just add one small remark that this should be seen in conjunction with Article 6. Still, you need indeed basis from there, and in this case, yeah, the from Article 6, public interest has been used mainly for processing health-related data in this context, and of course, in conjunction with Article 9.2 I for indeed for public interest in the context of public health, which is of course very true. So as you mentioned, that the responses in different countries has been very different. You started with China as a maybe kind of extreme case in terms of maybe two big, let's say, issues that you highlighted. I frame it as first of all, the issue of transparency in terms of it's not very clear or it's not maybe adequately communicated that how these apps are developed or what are the issues related to data protection. And of course, this is very important as I want to emphasize it again, that how the principle of transparency in this context is really playing a role, and maybe eventually it's even more important because we need to convince the population that, in a sense, that these apps are secure and safe, and just convince them in a way to download them and to use them. And of course, a second issue, which is it's related to voluntariness of indeed using these apps, and we know that different countries have different approaches. And of course, in Europe, the idea is that, as you mentioned later on, that the idea is that this should be the use of these apps to be voluntary and be on a voluntary basis. You referred as well to the E-Privacy Directive, I think, very briefly. Of course, that's also important because we know here we also need to refer to, I mean, it's important to have also, I mean, just installing app needs consent as well. And in that sense, that directive is also important for our discussion. In the context of Europe, you kind of bundle them together as a, like one general, let's say, approach in Europe. And of course, I think it somehow makes sense because you referred a lot also to the different, let's say, efforts, mainly in terms of pan-European privacy preserving proximity tracing. Yeah, but still, as you know, and maybe you've been following the discussion in different member states, we have seen that different approaches still has been taken regarding developing these apps. So I think in that sense, maybe, yeah, if you want to further work on this paper, maybe later on, I think it's also interesting to discuss further issues related to use of more centralized or decentralized approach when it comes to this, let's say, this pan-European approach in general. And I think you would see immediately that different member states has taken different approaches in this context. And I think this is a very important discussion for us because it brings also brings forward another, let's say, important discussion about trade-offs that, well, we need these apps, of course, and it's very clear that this is necessary for a very reason of fighting a pandemic and for a public health, let's say, emergency in this context. But at the same time, we are speaking about making sure that we are respecting right to privacy of the individual as far as possible, as much as possible. So I think that what I think that would be a really interesting discussion to be added to this paper is that to see that how these different approaches, and specifically in the context of, for example, choosing centralized versus decentralized approaches, how these indeed trade-offs in different countries have been indeed addressed. And I know that's not, there is no easy answer to that, and but I think it's worth exploring the different, let's say, arguments that's been put forward against and for of using either of these approaches. And I think in that sense, it's also interesting to refer to, I think you briefly refer to the exposure notification system from Google and from Apple in their indeed their system. And this is also relevant to discussion of picking either centralized or decentralized approach and the issues related to compatibility with indeed with this notification system, which I think that was one of the reasons that some countries favored, let's say, decentralized approach. So I think that that's something that maybe at this moment is not really fully developed in your paper, but it's something that you can definitely add there. I think it's you also added and referred already to issues related to well, in different countries, different approaches have been adopted, and sometimes this is not necessarily has just a legal, let's say, reason behind it. Cultural, socio-cultural issues played a very important role. And I think I just want to say that I fully agree with that, and I think this is a topic that it's really difficult to limit it to just to data protection regulation and to this legal framework, and there are many other elements of playing a role to eventually make this work. And of course, privacy-related issues are very important. And it's necessary to make sure that the techniques that are being used, for example, for when it's possible anonymization, but you also argued that this is it's very difficult to reach that level, but also besides the technical measures, still it's important to make sure that there are adequate safeguards in place, and eventually making a product that it can be indeed used by the different populations in different countries, taking into consideration different cultural and social issues, and eventually this can be used, because this is the ultimate goal. It's otherwise it's pretty much useless. I think that's pretty much all the points that I had on your paper. And if you want to, I don't know, answer some of these, just more comments on these remarks, or
yes,
very welcome.
Thank you very much for your comments. And I know there is still to work on this paper, because as I said before, is constantly changing and is developing on really daily. Daily is changing, and I think that is even important to have a look on this topic, even to see how it will be in the future after the situation of emergency will end. And so we have to see how this introduction of smart purchasing apps will have an impact on other aspects or other fields, and even if this data will be used for something else. So yes, definitely there is so much to see and to work and to look deepen.
Sure.
Thank you.
No problem.
Okay, thank you very much. So I actually have a question. So Mahsa, considering your expertise in health privacy, so you sort of identified this aspect of the paper of Marialuciana that could be developed further. Mm-hmm. So I was wondering, you mentioned how different member states found different approaches in terms of centralized, decentralized applications. I thought whether you would like to sort of build upon that and put forward a little bit your own perspective, and also if you have some interesting elements about the Belgian perspective on this as well, or any other member state that has not been mentioned by Marialuciana in her part.
Sure. So I will just immediately give a kind of insight from a Belgian perspective. So the approach that's been taken here, it's a decentralized approach. And I think the advantage here is that, of course, you can give more control, in a sense, to the citizens, in a way that their data are the way that's being processed. And I think what I found it also very helpful is that the report of the data protection impact assessment from the Corona Alert app in Belgium is published and it's available. And besides that, other more like accessible information about how the app has been developed has been made available also to, let's say, general public. And I think I found all these important, in a sense, because, as I mentioned, I think transparency is also very important in this process. In a sense, sometimes it's really difficult to explain all the technicalities. Of course, we speak about pseudonymization, different techniques, but in a sense, at the end users are general public. And it's very important to make it, of course, in a sense, accessible to general public, all this technical information. But still, I think one of the challenges is that, as I mentioned, the uptake is not very high. I think the latest number that we had here was around 10% of the population, I think, even less.
Okay, thank you very much. I'm sorry, some drilling actually started on my side now. So I see Michael posted in the chat mentioning that the DPIA from the Swiss app and the decentralized system that they designed together is available. The legal analysis of it is available, and also the UK DPIA, as well as the German one. So of course, also for all those interested in this, these are some really useful resources, and especially Marialuciana, if you would like to sort of implement also these opinions in your own research. I see we also have some questions in the Q&A. So first of all, Michael Suda is mentioning the Austrian perspective, I believe. So he's asking whether someone or is aware or has read through this COE report on digital solutions to fight COVID-19. Of course, since I believe we have quite a few Austrians in the audience, you're very welcome to give feedback on this if you have more expertise. We also have a question from an anonymous attendee asking, so the voluntarily downloading of COVID tracing apps relies heavily on trust in the technology and those processing the personal data. Do you think principles found in Article 5 of the GDPR, such as fairness, transparency, accountability, etc., could assist in building trust in the apps?
If Marialucia, you want to add anything, or maybe I can immediately say that, well, as I already mentioned, yeah, transparency, I think that's something that we already mentioned, that it's very important, because I think still for many citizens, despite all this information has been made available, they're still not very sure that how much information actually from them can be shared by public health authorities. And of course, it's also this kind of somehow misgivings or concerns about long-term, let's say, storage of this data, or potential secondary uses of this data, or unintended uses of this data. So I think that these are all aspects that needs to be very clear and to be really communicated in a transparent way. And I agree that, yeah, this is, I mean, all different experts have different role to play, technical experts, legal experts, but at the end of the day, you should make this a convincing case. Otherwise, if, yeah, the general population are not using this app, then it means that it's quite futile what has been done.
Yes, I think that in this case is not that much about transparency as accountability, but how it is perceived by the population and how it is communicated to the major part of the population. Because, as you said before, there are many technicalities, and people are completely aware of the implication of downloading or not downloading the app. So I think that is even important, the communication and how these principles are effectively communicated to the population. So this.
Yes, thank you very much. I was also thinking about the very end of Michael's presentation mentioning limitation, so also purpose limitation in this concept, in this context. We have another question. So the EU Commission just recently announced the interoperability of the Italian, Irish, and German contact tracing apps on the European level. How do you see such move affecting data protection rights?
Well, I personally, I haven't seen the document yet. So in general, I would say, but it's important in terms of interoperability. That's what it's necessary as well, considering the, I mean, mobility of the different citizens. And I think this is something that it's necessary to be realized. But of course, at the end of the day, you need to make sure that this is in the framework of the different principles and rights, which is respected and protected within the data protection regulation. So yeah, I rather limit myself to this very general remark.
Do you have any comment, Marialuciana, or?
No, just saying that as I write on my paper, an interoperability approach is highly recommended because of in terms of maintaining the freedom of movements between European citizens. So if there are respected rights under the GDPR and other privacy laws, I think that could be only useful.
Okay, thank you. I think on this point also, Michael Veal added that interestingly, different DPIAs consider the backend data personal data or not. Irish considered so the Irish DPIAs considered it non-personal data, and he's inclined to agree with this. Do you have any opinion on this? Are you also inclined to agree with the Irish position?
No, I don't really have any specific comment on this. I think the discussion is going on.
I think he was just correcting his DPIA.
I see. Yeah.
Okay, so I also have Michael, the Austrian comment I mentioned earlier, explaining that what he meant is that the report says that the future use of the app could be crowd control and contact tracing, something that is totally contrary to the data protection friendly approach of the Austrian Red Cross Society.
Mm-hmm. Yeah, I see.
Do you have any experience by any chance, or anybody in the audience, of similar NGOs that sort of are like in a situation where they have to go for a rather, well, I'm not saying privacy unfriendly approach, but definitely more questionable approach as the one mentioned here by Michael in Austria? Or you don't have this experience, for example, in Belgium?
I cannot really recall any experience now from Belgium, but I see that somebody else is answering that the Italian DPA considers backend, but I think it's in another point.
Yes, so I think Michael Veal again, which I am inclined to add to the panel now with all the activity in the Q&A, is highlighting that, in his opinion, it's not possible to do either of these things with a decentralized exposure notification, and what he was involved in designing made sure that this couldn't be expanded in this way technically. So he mentions that it would have to start from scratch, and then it wouldn't work, for example, on iPhones. Yeah,
I think I agree with that as well. That's a problem also with if you want to still use the features on your iPhone, then you need to, I mean, for the compatibility purposes, then the decentralized approach is favored there.
Okay, so I think the other Michael also agreeing, so that's good. Are there any further questions? Or, because I think now I answered everything from the chat, I don't see any raised hands, and also from the Q&A. So if this is the case, then we have quite a long break. So this is a good opportunity to catch up with all those emails you've been postponing because you were following us with so much attention. So we have quite a long break until 4, and then we will have the third junior senior tandem session, and then we will have a panel discussion with the senior researchers and the closing remarks. So please stay tuned, and we will meet again at 4. Thank you very much for the very interesting discussions and presentations.